If you have Italian ancestors, you could be eligible for Italian citizenship. However, navigating the process can feel like traversing a complex maze, especially when it comes to a specific hurdle known as the minor issue. This issue arises from differing interpretations of Italian citizenship law, specifically regarding individuals whose Italian parents naturalized in another country before their birth. Adding another layer to this complex issue, a new administrative set of guidelines known as Circolare was issued in October 2024. This directive clarifies the Italian government's stance on the minor issue, impacting how individuals can claim Italian citizenship through their ancestors. This video tries to explain the complexities of this issue, exploring the historical context, legal precedents, and potential solutions to help you understand your options better. To understand the complexities of the minor issue, we must first turn back the clock to 1912, when Italy's Law 555 laid the foundation for Italian citizenship by descent. This law, rooted in the principle of iure sanguinis, established that citizenship could be passed down from generation to generation, regardless of where subsequent generations were born. While seemingly straightforward, the language used in Law 555 left room for interpretation, particularly concerning children born before their Italian parents had naturalized in another country. At the heart of the minor issue lies a clash between two articles within Law 555, Article 7 and Article 12. Article 7 states that if your ancestor was born in a iure soli country, such as the US, to an Italian father, he retained his Italian citizenship until he renounced it as an adult, usually at the age of 21, regardless of whether the father had naturalized earlier. However, Article 12 apparently states that if a child is a minor and his parent naturalizes in another country, the child loses his Italian nationality if he is still under the legal authority of the parent. Do you see the conflict? In fact, these two articles have since been correctly interpreted by municipalities and consulates to allow the recognition of citizenship in the case of descendants of an ancestor whose father had naturalized during the child's minority. This interpretation has lasted over 112 years. Until October 2024. The Italian Ministry of the Interior indeed issued in October a new Circolare, a directive intended to provide clarity on administrative procedures. This particular circular addressed the minor issue, stating that Italian ancestors born in a iure soli country whose Italian father naturalized in another country while they were still minors would lose their Italian citizenship without being able to pass it on their offspring. This pronouncement sent ripples of concern through those pursuing Italian citizenship, as it seemingly closed the door on many who believed they were eligible. In the current ever-changing landscape of Italian citizenship, a significant opportunity is emerging through the Italian judicial system for those who are no longer able to apply to a consulate or town hall because of this new circolare. In fact, while Italian consulates and municipalities are strictly applying the new interpretation of the law on the question of minors, Italian courts are maintaining their own interpretive autonomy with regard to the Italian citizenship law. The possibility of applying to the Italian courts before the Circolare was open only in two other scenarios: when the waiting time at the consulates exceeds 730 days, and in cases where a female ancestor gave birth to her offspring before 1948. This route, which involves some procedural complexities, shows positive results in the majority of cases presented, and there is no reason to expect a sudden change in the trend in the short term. While the judicial route may be a viable alternative for those affected by the minor issue, there are other ways to obtain Italian citizenship through the administrative route, be it through the consulate or the town hall. One such path is claiming citizenship through the maternal line. Before 1948, Italian women could not automatically pass on their citizenship to their children. However, a landmark court ruling in 1983 recognized the right of women to transmit citizenship retroactively. This means individuals with Italian mothers born before 1948 may be eligible for Italian citizenship, even if their fathers were not Italian citizens. Circolares play a crucial role in the Italian legal system. Although not laws themselves, they provide administrative guidance on implementing existing laws. While they carry significant weight, they are not set in stone and can be challenged in court. The many favorable recent court rulings regarding the minor issue demonstrate this point, highlighting the dynamic nature of legal interpretation in Italy. Navigating the complexities of Italian citizenship law, especially concerning the minor issue, can be daunting. However, it's essential to remember that you are not alone. Many individuals have successfully claimed their Italian citizenship, even in the face of seemingly insurmountable obstacles. Recent court rulings have given reason for hope, showing that the 2024 Circolare is not the last word on the subject. The complexities of Italian citizenship law, particularly regarding the minor issue, highlight the importance of seeking expert guidance. An experienced Italian citizenship lawyer can help you navigate the legal maze, interpret court rulings, and develop a tailored strategy for your unique circumstances. While the journey may seem challenging, remember that with the right guidance and a steadfast spirit, your Italian citizenship dreams can become a reality. Visit nowitaly.get.com and fill out the contact form. We'll immediately set a free consultation call to help you get started with your citizenship journey today. If you like this video, support our channel touching the thumbs up button and hitting subscribe.